Hey, everybody, and welcome to a new episode of Eating at a Meeting. And as this is going, Alexa is going off downstairs. Sorry. um, I am so excited to be here with you today to bring you another episode of Eating at a Meeting. I'm Tracy Stuckrath, and today we are talking about food allergies and the Americans with Disabilities Act amendments, Americans with Disabilities Amendments Act. And a deep dive into the legal protections that it does. And it was 16 years ago today that it was enacted or signed into law. Laurel, you can correct me on how I say that.
That's right.
And so I want to talk to my friend Laurel here, Francoeur. She is an attorney with a passion for advocating for individuals and families affected by food allergies and other disabilities, especially related around food and beverage. She provides comprehensive legal services tailored to unique needs and challenges, and based out of Massachusetts. So, hello, how are you?
Hello. Good. How are you?
I am good. Okay, so we have chatted in the past, everybody, on episode 211, which is actually almost a year ago. We talked a little bit about how to ensure equal access and how the ADA applies to that. But I really want to focus in on the Amendments Act that was enacted 16 years ago. And in my presentations that I do, I actually always ask the question, I'm like, did you all know that the ADA was amended in 2008? And most people are like, no. And so I tell them that it was, and then I tell them why it was in my layman terms, but I would really love for you to explain what the Amendments Act is, and then what it did.
What happened was Congress realized that there were some cases where, and one including a Supreme Court case, where the definition of disability was being shortened. I mean, so in other words, courts were trying to make it harder and harder for people to prove that they were disabled. And so Congress got word of this and said, this really isn't what the ADA was intended. We really intended it to be interpreted broadly, to include as many people as possible. Okay. So what they did in reaction to that was they amended the ADA, which had been passed in 1990. So a few things that they changed. So in order to be considered disabled under the ADA, you have to have a major life activity. So that's something that substantially limits a major impact life activity. So one of the things that they did is they expanded what they considered life activities. So that helped, especially people in the food allergy world, because they added more things. So they added things like it affects your immune system. Does it affect your neurological system? So they broadened what they considered to be major life activities. They also changed a couple other things. So in the past, you used to be able to rely on what's called mitigating measures. And so you can't do that anymore. So the biggest case I could think of was sort of with asthma. So the cases before this would say, as long as you have your inhaler, once you take your inhaler, then you're equivalent to everybody else. You're no longer disabled. So for instance, with food allergies, it would be once you give yourself an EpiPen, then you're no longer disabled. So Congress said, no, you can't do that. You can't say because they have something that helps their disability, that makes them no longer disabled. So that was one of the big changes.
Can I just interrupt there?
Because sure.
That would say, like, if somebody was given a wheelchair, that they're now no longer disabled.
Yeah.
Okay. I mean, just comparing those two things. Yeah.
Yeah.
Okay.
Yeah. So then another thing that they did was they said you have to look at your disability when it's active. So something that's episodic. So like, for instance, with food allergies, you're not having a food allergic reaction 24 hours a day, 7 days a week. So you can't say, well, today you're not having a reaction, so you don't have food allergies or you're not disabled. You have to consider it as if it were active. So you have to consider what happens to a person when they are having an allergic reaction. And so the fact that they're not having an allergic reaction all the time doesn't mean that they're not disabled. So that was another big change.
Okay. Because, I mean, and again, I mean, food allergy, you never know when it's going to hit you.
Right.
And so you have to be cautious all the time, basically.
Right. And then there was another case before that. It's called the Land versus Baptist Medical case, which held that food allergy, in this particular one was peanut allergy, is not a disability. And they said, because, well, you can eat things other than peanuts and not have a reaction. So your eating
Right.
really isn't affected. It's only affected when you eat that one thing. And so that was before the ADA was amended. So now after the ADA is amended, that's no longer valid. You will find some courts still refer back to that case, though. But you can't say that now. You have to say, if you were having an allergic reaction, what would it affect? What major life activities would it affect at that time? And if it affects one of these in a major way, like eating, breathing, then it is considered a disability.
Well, and one of the things that I like to point out too is I think the word eating was actually added to that list of major life activities because it wasn't before, right? It was just
Yes,
hearing
yeah,
and yeah.
yeah.
And I was actually talking to a friend of mine this morning about her son. He's got celiac disease, and um, he couldn't figure out what, and he was being fed food by a company, his company, and it was the spices that they were using that actually had the gluten in them, which because they couldn't figure out because he wasn't physically eating any other kind of gluten, and it finally was that.
Wow.
And so in that kind of peanut cases, you don't know, right? Because
Right,
it's hidden.
exactly.
Right. Yeah.
Exactly. Exactly.
Yeah. So what have you seen change over the last 16 years? Have you seen, I mean, you said that case was before the amendment. So, and I know that there's been the Leslie University case
Yes.
and there's been the Williamsburg case with the young student. I mean, are those kind of the two, I'm going to say banner cases that have done, has anything else really changed because of the Amendments Act?
I think the biggest thing is awareness. So it's brought
Okay.
awareness to a lot of people, and a lot of organizations that thought maybe they didn't have to do any modifications, but now they do. So one of the cases that I had involved a woman who was went to a pharmacy and wasn't able to get the list of ingredients, of inactive ingredients in the medication,
Mm-hmm.
and the pharmacy wouldn't provide that. And so we had a decision in court where it said it could be a reasonable accommodation for a pharmacy to have to disclose all of the ingredients, even the inactive ingredients, and also to wipe the tray. So the court said, because they didn't want to have to wipe the tray. So, for instance, if somebody had antibiotics beforehand and you were allergic to antibiotics, you'd get the traces. So that was another case. So it's getting to, again, more known that this is a disability and that things have to be modified for people.
Okay, so that boggles my mind too. I mean, because that's a pill, right? That's made with different ingredients, and it's so then you jump to meetings. I'm like, they're saying yes, that's a reasonable accommodation to provide the ingredients of medication. You know, it should be the same thing for a catering company, right?
It should, but the problem with that is you have, so in Massachusetts, we had a restaurant bill, and it was
Mm-hmm.
going to require restaurants to have basically what's called a Bible. So list of ingredients of all foods that they had. And we got a lot of pushback from the National Restaurant Association because they were saying that people have proprietary recipes. So they
Mm-hmm.
shouldn't have to disclose their recipes.
Right.
So they pushed back on that. So the compromise that they came up with in Massachusetts was then the patron then will inform them of their food allergies. And then if that allergen is in the recipe, they have to disclose that. But they
Right.
don't have to disclose all of the ingredients in the recipe. So that's kind
Interesting.
of where we had the pushback. Yeah.
Okay. I mean, and I kind of joke about that because I'm like, it's the Bush's baked beans, right? I'm like, I don't, the dog is the only one with the, with the recipe, right?
Yeah.
I don't want the recipe. I just want to know the ingredients, right? Yeah. All right.
Yeah.
So
So
Nancy
you don't have to
go.
give all the ingredients, just the allergens. If somebody
Okay.
asks, if somebody says, I have a peanut allergy, is there peanuts in this? They have to declare that. They don't have to tell you every other allergen unless you ask.
Well, okay, so like if somebody was allergic to corn or garlic, can they ask that, or under that law are they only required to tell you the top 9?
No. So whenever somebody in Massachusetts asks, is there an allergen in this, then they have to disclose that.
Okay.
But then this is different from packaged foods. So we're talking about the
Mhm.
restaurant experience. We're not talking
Right.
about packaged foods because that's
Right.
totally different.
Exactly. Yeah, that's a whole nother thing. Nancy put in here, she did not know that the spices with gluten. So I think it's kind of the cross contact kind of thing. But also there's the cinnamon recall that's happening right now that cinnamon has lead in it. And so I'll find the links to that if anybody's curious about that. But even in the UK, I actually asked a question on LinkedIn the other day because there's a recall of mustard because there's peanuts in the mustard.
Wow, you wouldn't think that, would you?
Right, exactly. So I put on there, I'm like, is that only mustard made in the UK, or is that mustard that's being, shipped across the world? Because that would, be relevant to us as well. And then I'm going to pull up, Margaret just put up here, the pharmacy issue is another reason why we need to get the ADAAA Act passed. So,
Exactly.
Which is really about labeling of allergens in medicine, right?
Exactly. The inactive ingredients, yeah.
And Margaret put a full thing on there. Thank you, Margaret. I'll share that out too, to everybody else. So when we're talking about, and I think you kind of mentioned this as well, but in the ADAAA, what does it mean for an individual to be regarded as having a disability, and how does that apply to food allergies? We kind of already answered that. Did you, or can you answer
Yes,
it
so
again?
the ADA Amendments Act also made that easier to prove. So if somebody is regarded as having a disability, even if they technically may not fit the definition of a disability, but if everybody around them assumes that that's what they have and treats them as if they had the disability, then they're entitled to accommodations as well.
All right. Can you give an example of what that could be?
Well, it's hard in the food allergy context because, like you said,
Okay.
it's sort of black and white. Like you have food
Right.
allergies or you don't.
Right.
But it might be like anxiety. Maybe somebody who has, an
Okay.
anxiety disorder, and everybody knows, treats them like they're, delicate or fragile around them.
Right. Mm-hmm.
So then, even though maybe the anxiety doesn't rise to the level of a disability, if everybody says, "Oh, we have to be careful with this person because."
Okay.
Of their anxiety. It's kind of hard to
Right.
hard to
No,
define,
that,
but yeah.
okay. Well, and if you're disclosing, in a couple of weeks ago, or a couple of months ago, I had Ryan Gambala on talking about food safety, and he was, and I'm relating this to what you just said, is because he represents the restaurant hotel side of the industry, but he said as soon as someone in the restaurant has been notified that Laurel has a food allergy, then the entire restaurant is then kind of now on notice that and
Exactly.
must follow the chain of command in making sure that that person is safe.
Exactly.
So even if it was the busboy. Yeah.
Right. Yeah. And
Right.
if they
Yeah.
did, yeah, then it would be up on the busboy to communicate that to the chef. But the restaurant is responsible for its employees.
Right. Okay.
Yeah.
So how do we, and my next question relates to some cases, and we talked about, and we've, I mentioned the Leslie University case and the Williamsburg case, and maybe we should reiterate kind of how those were landmark in this. Can you do that real quick?
So with Leslie, it was a woman who went to Leslie University who had celiac disease, and she had to pay for a meal plan, even though there was nothing she could buy that was gluten-free. And so the DOJ, Department of Justice, got involved, and they negotiated an agreement with Leslie University that said that she could be exempt from the meal plan, and they also had to provide her with gluten-free meals. She had to be able to put in her request 24 hours in advance for a gluten-free meal, and they would have to abide by that. So that was sort of the major case that we had involving colleges and whether they have to accommodate for food allergies. The Williamsburg case was a boy who went to Williamsburg on a field trip and had communicated that he had celiac disease. And when he got there, they made him sit outside in the rain and eat his food in the rain because he brought his own food. So in that case, the court said it could be a reasonable accommodation to bring food in to a restaurant.
And that actually had to go to appeal because I sat in that appeal case. Yeah. So how has that I lost my question when I had a question for you based on those two things, but I lost it. So right now there's a case out there, Captain McKenzie, who's a pilot for United Airlines, has filed suit against United Airlines because kind of in the Williamsburg case, right? He can't eat while he's working, and they provide. Let's see. It says they provide him food while he's working, but the food, and they deduct money from his paycheck to pay for that food, but he can't eat any of the food.
Right. And they also, I guess, mandate him to stay in certain hotels, and those hotels may not have gluten-free restaurants.
So how, looking at it from that perspective of comparing Lesley University and Williamsburg, I think it might have a good big precedence depending on how it comes out.
Yeah, so this now involves an employer. So it's basically an employee suing his employer, saying that because you're subject to the ADA, I'm entitled to get certain accommodations. So in a way, it's different because Lesley was a college student and Williamsburg was a high school student. So this is actually an employee suing his employer. So it'll be interesting to see how it pans out.
Exactly. I mean, because I'm thinking company cafeterias, company events, where you're coming to, and even in the world I am, not just like a meeting in the office, but an incentive trip. If like I sell them enough widgets for you and you honor me with a trip to, Timbuktu, you need to feed me on that too. I mean,
the airline is going to have some defenses, though. I'm not sure if they're going to hold up. But so if they can say that this is going to be a fundamental alteration of the way that they do things, which I think that's going to be kind of hard to prove. I mean,
right.
But also if they could say it's an undue burden for them to have to provide gluten-free meals, that's another defense that they have. Again, I don't think that's going to go very far, but they do have those defenses. So for a smaller company that really, if having to accommodate is really going to be a big financial burden on them, they may be able to push back and say, I don't have to do this. And they may not have to. So
it'd be interesting to find out how many other employees, though, have celiac disease.
Oh, I'm sure lots.
Yeah. And have that same problem, right?
Yeah.
So, and the ADA applies to organizations with 15 or more employees. Is that right?
Yes. Yeah.
Okay. And then what about, because I was chatting with somebody the other day, private country clubs. Does it apply to them?
No, unless they have events that are open to the public.
Okay. Or they rent to the public.
Exactly.
Okay.
But if it's just a members only thing, they don't have to be ADA compliant. But once they host, like you said, a fundraiser where the public is invited to come in, another issue that we've had is, so for instance, if a church group is immune from the ADA, but then they decide they want to have a preschool come in, then all of a sudden they're now subject to the ADA.
Interesting. Okay.
Yeah.
So the little tiny things of what kind of services you provide might change that.
Exactly.
Yeah. And how would somebody, I mean, how would an organization then know that all of a sudden now they have to abide by the ADA?
Well, hopefully they have lawyers advising them. But if not, they could get sued. And there have been with the ADA, especially with access and barrier cases, there have been these ADA, I don't know if you heard, these ADA testers who go around and test. So they'll say, I tried to get into this building and it didn't have a ramp. so I'm going to sue. So there were a lot of cases that have sort of propped up. It's kind of like a cottage industry among lawyers,
Right.
actually, who do these, because the lawyers get attorney's fees paid from the other side.
Okay.
So they have an incentive to take these cases. I mean, it
Gotcha.
does help people, but it also, people sometimes think, oh, this is, a little too much on
Right.
the other side.
Right. So what legal precedents exist concerning employers' obligations to accommodate dietary restrictions? I mean, because you just said the undue burden, right? If it's going to be financially challenging to do that, but I'm going to say ordering a pizza from a gluten-free pizza shop versus ordering pizza from Domino's is not necessarily, doesn't fall into an undue burden.
Mm-hmm.
Is that right?
Yeah,
What
yeah.
other kinds of things would exist?
There are very few cases on this. So that's
Okay.
why I think this case will be a big case,
Okay.
because we don't have a lot of precedent on this issue
Okay.
of how much an employer has to accommodate.
Okay.
So we'll see. Yeah.
Yeah. I mean, because it does come down to, I mean, I remember, and I've told this story before, is like, celebrating the staff birthday in my department. My company had 80,000 people in it, but in my department, they brought cake, and my boss is like, just eat the damn cake. I'm like,
Wow.
I'm not going to eat the cake. Right. And I mean, it made me feel really like crappy. I have stronger words there instead, but by somebody saying that to me. But then again, I'm like, one, it's okay for me not to participate in the cake, right? Eating, but don't be mean like that.
Well, and then are you afraid it's going to affect the way your boss views you from then on? So I had a case where a man worked for a nonprofit, and he was sort of harassed with peanut butter. So they would have peanut butter in the break room, and he would say, I really can't be around this. And so he eventually sued, and that case settled. But you feel as though you're not, they don't consider you a team player. So for instance, there was an event where where they were all going out to dinner, and they didn't invite him to the dinner because of his food allergies. So,
wow.
Yeah. So you feel like I'm not one of the team, and maybe I won't get the raises, maybe I won't get the promotions because I'm not seen as equal to everyone else. Okay.
Well, you just said a really interesting word, because yesterday, I don't know if you follow the guy Will Guidara. Do you watch the movie, or do you watch the TV show The Bear?
No, I want to start watching.
You need
I've heard wonderful things about it.
Yeah. It's really good. But he has a book called Unreasonable Hospitality. And he posted, I'm going to look it up, make sure I get this right. Something yesterday that just completely resonated with me and what we're talking about. He said, hospitality is making people feel seen. And I think it really pertains to this, because I'm like, as we're trying to make, order food and beverage or have a staff meeting, and just kind of going to that, I'm like, you're pushing them out. You're not seeing them as who they are.
Exactly.
Right? And not providing that hospitable environment.
So Paul Antico, who does food allergy eats, I don't know if you're familiar with him. The website, sort of like a Yelp for people with food allergies.
Yep.
He used to talk to restaurant owners and saying, if you don't.
I lost you. Hopefully you guys can hear her. I can't hear her. Oh, there we go.
Can you hear me?
Yep.
So if a restaurant doesn't make accommodations for any other dietary need, then they may not have to accommodate for food allergies. So he would go around to restaurants and say, if you decide you're not going to feed that one allergic customer, think of how many other customers you've now lost. You've lost their family and friends, and then they're going to tell people. And so you may think, well, in the short term, I don't have to feed this person who has an allergy, and it'll be easier. But now look at all the revenue you've lost, because you haven't just lost that person, you've lost everyone associated with that person.
Right. Exactly. And if you're thinking, if somebody's having a meeting, and it's a group of 25 people, that's a large chunk of change that you might lose out from that. And actually, an example of that personally is that I went on site visit with one of my clients. This was years ago, and the Convention and Visitors Bureau shared my dietary needs with all of the hotels we were visiting. And one hotel decided to do a chef's table to introduce us to their food and beverage. And my clients were sitting at the far end there. I'm sitting next to the woman from the Convention and Visitors Bureau. They brought out the food, and every dish they brought out had my allergen on it.
Oh.
And, and the chef was like, oh yeah, we did get that, but we missed making you a meal. Well, that program overall was, I think the whole budget was like $400,000 that we would have been spending at that hotel. And my client, because of what they witnessed me going through, chose a different property.
Wow.
So, I mean, that's a clear example, like really reiterating Paul's, information about the financial implications is huge. Okay, so I want to clarify around on ADA here a little bit too, because when we're thinking about a meeting planner, and I want to also think about, you've got employees, you've got a meeting attendee, you've got speakers and or vendors that you're paying, to come speak at your event. Does the ADA change depending on what that person's category is in relation to that event? Does that make sense?
So you mean depending on what your participation is in the event, whether you're entitled to accommodations?
Right. Yeah. So if company XYZ is hosting a meeting for their employees, right? So you've got the employee, and then they hire you or I to be a speaker. And then maybe there's some contractors. Does the ADA apply differently to us?
Well, so if for the employer, again, if they have more than 15 employees, then they have to accommodate their employees. Okay. If it's an event that's considered in a public accommodation, so if it's an event that's open to the public, then now they're under another part of the ADA, Title III, which means now that they're having an event that's open to the public, so they have to accommodate. So they kind of get hit both ways with something like that.
And then if it was at a convention center that's owned by the state or the city, how does the ADA, is that another level of ADA accommodation?
Yep. So states and local governments are subject to the ADA. It's a different title. It's Title II. But one of the things that we were talking about, where we need work done is some states now have been pushing back and using what's called sovereign immunity.
Okay.
I don't know why it dropped there.
I don't know. I'm going to close out on some stuff and see if I can, maybe it's my Wi-Fi, but go ahead. They're using sovereign immunity.
Yeah. So this is in regards to like professional testing. So like say the bar exam. So it used to be, there's a part of Title III that says any organization that gives a professional licensing exam has to make it accessible for people with disabilities.
You would think, yeah.
And so the cases in the past would say, yes, they have to accommodate. But then they came up with this idea of sovereign immunity. So if a state is hosting the exam, they could argue under the ADA, well, we don't have to, we're separate from the federal government. The 11th Amendment to the Constitution guarantees that states have Did I fall out again?
You did. This 11th Amendment guarantees that they have sovereign immunity?
Yeah. So unless the state agrees to be sued under the ADA, or unless the issue is something that implicates an equal due process right under 14th Amendment, then they could somebody who was taking a bar exam and asked for accommodations, and they had trouble getting the accommodations and had an instance with that and went to sue. And the state is saying, we're not responsible because we're sovereign. We don't have to follow the ADA. And so far, the lower court in that case has said, yes, they don't have to follow the ADA. So we're appealing that. So I'm hoping we'll get a different result.
Yeah, I mean, that would make a lot of changes across the country.
It would. Especially so, for instance, with professional licensing exams, one of our arguments is that is done by the state. I mean, states are the ones who give licenses, professional licenses. It's not individual people. So, and the ADA specifically says that any place that gives a professional license exam has to accommodate. But even if it is a state, but the states are pushing back and courts are going along with it, unfortunately, and saying, okay, yeah, they are immune.
Wow. I see lots of problems with that across the board for individuals in a variety of different disabilities across the board, and or issues with the government in general.
There's a recent case involving voter access.
I have no idea why you keep calling it. I'm hoping it's good on your end. So there's a
Ethernet. So hopefully,
case. Yeah, there's a recent case
involving voter rights. This came up involving voter rights, where this came up, where the state basically said we don't have to accommodate because we're sovereign for state elections. So
what?
It's troubling that it's gaining ground. It's sort of like almost like a creative lawyer, found out this a few years ago, and now everybody's using it. So I hope we're not going to see it in more places. But
well, and with all the other issues or challenges that we have with voter rights right now, that's not one that we need to be bringing up. I mean, because how many people in the country have disabilities, right? I mean, there's a large contingency, and I think the statistic is that they have a larger spending power than anyone else, any other group in the country. Not food allergy related, but just disabilities in general.
Yeah. And then I do have people who push back who have food allergies and say, I don't want to be considered disabled. There's a stigma around that. But I tell people, really, it's a legal word, so it's the word you have to use to get the accommodations. So, try not to realize that it has any stigma or with it. It's just sort of a legal word that we use to make it so that you can get the accommodations.
Well, and that I think brings up a good point, because there's a lot of people who don't tell people, meeting planners and such, that they have food allergies or celiac disease because they don't want to be seen as a burden. But at the same time, I'm like, I don't want to kill you, right? So tell me so I can feed you safely.
Yeah. Well, and there's the whole thing about, so I know that there was a Disney case that had the death, but there's also with Disney this service. I don't know if you're familiar with this.
Mm-mm.
So what was happening, Disney thought a lot of people were faking disabilities so that they could get extra privileges or get in line faster or so forth. So Disney and Universal and a lot of the parks then came up with this idea of having a card. And so what you have to do, and it includes food allergies on it, by the way, which is really weird. But you have to go to a third party that they hire and give them all your medical information. And then that third party determines whether or not you have a disability. And you don't know what criteria they're using. They also say that they have the right to call your doctor and get medical information about you. So then if this third party company decides that you have a disability, then they issue you a card. And the card has a code where if you scan it, you can get all the information about the person.
Wow.
Yeah.
That's scary.
Food allergies fall under that. So and it's totally wrong, because you shouldn't have to disclose what your disability is. You shouldn't have to give medical information to a third party that you don't know what they're doing with it or what decisions they're making. And It's scary.
That brings up a whole conversation that I had with an attorney from Merritt's, which is an event planning company. And I was chatting with their lawyer, Jill Blood, and we were talking about the new laws of the My Health, My Data laws, which I think it's in the state of Washington right now. And it's kind of like a HIPAA thing, is like, how are we protecting the data of those guests who are coming through? And it could be one, that you're having a meeting in the state of Washington, or two, your person lives in the state of Washington and is attending your event somewhere else. That law still pertains. And it's kind of like GDPR is like, how are you going to protect that information?
Yeah. So there's a lot of pushback against. I've argued that it's contrary to the ADA, because one of the things is also service animals. Mm-hmm. So if you have a service animal, a place cannot ask you why you have the service animal. They can only ask you, is it licensed? Is it registered? But they can't say, what is your disability that requires you to have a service animal? But now this service, you have to even disclose that. And they have to evaluate it to see whether it's legitimate or not.
Yeah. Who's the person that came up with this third-party company to analyze the disabilities?
I don't know, but it's
wow.
It's crazy. It's crazy.
That is very, very scary. Okay, so what advice would that brings up so many things. So what advice would you give to an attendee, somebody who has food allergies or celiac disease, in sharing that information out? And then what advice do you give to that employer or to that meeting planner in managing this information and that data?
Yeah. So, hopefully, and that was another thing that the ADA Amendments Act amended, was that it's not supposed to be as rigorous a test to prove that you have a disability. Mm-hmm. So hopefully, you wouldn't. So let's say an attendee was coming and had food allergies. Hopefully you wouldn't say, well, let me see your medical record or let me see a doctor's note, or, hopefully you would take them on their word that really they have that. So hopefully you wouldn't have that sensitive information to begin with. But once you do, you should protect it. It's a double-edged sword, is you have to tell them about your food allergy in order to get the accommodations. But then once that's out, so like, for instance, an issue that we have, I had in school, I represented a family whose son was going into middle school and had a food allergy. And they decided to do a letter to the parents saying, don't bring in peanut products. Mm-hmm. But the letter said, Sean has a peanut allergy, so don't bring peanut products into the school. So then Sean, who's just starting middle school, trying to make new friends,
right
now everybody was saying, oh, we can't bring in peanuts because of Sean. Mm-hmm. So I had to go in and educate the principal and say, this is not right. The letter should have said someone in the class has a peanut allergy. Mm-hmm. But to say Sean, that made Sean a target. And so he had to start his middle school known as, he's the reason we can't have peanut butter.
Oh my God.
So you do have to be careful. This is that delicate personal information.
Right. Yeah. I've done it in the past where I'm like, and because we had a woman who was allergic to apples, and she couldn't be in the room with them except for phones and computers. Right. That was our little fun with that. But we put out, like, we've got somebody who is allergic to apples. Please do not bring anything that has apples in it into the meeting space. And somebody had a conniption with me. She's like, well, there's got to be apples in the hotel. And I'm like, I'm not asking you, the hotel, to clear itself of apples. I'm asking, we as attendees and you as the hotel, we're not going to serve anything that has apples in it in this confined space. Right. Mm-hmm. And the chef was really good with me. Like the day before, we went through all of the sauces and found, apple cider vinegar and things, and pulled that out. But it wasn't forcing. And even in an event this summer, I said, we have somebody that's anaphylactic to nuts and she cannot be in the room with the nuts. And they're like, well, we're not a nut-free environment. I said, I understand that. I said, but anything that you serve at our meeting must be nut-free. And she was good with that. I communicated that to the attendee. And of course, Laurel, the first event, they brought out 4 pastries, 2 of which had nuts in them.
Oh, no.
And I'm like, yeah. And thankfully the server caught it because it was written all over the banquet event order and pulled them out. But the pastry chef said, "Oh, I forgot."
Forgot.
Okay. Yeah.
Wow.
Yeah. So Sue put on here, I think part of the problem why the pendulum has swung so far to the other way is the number of people scamming the handicap system and service animals when they just want to park closer or bring their pet everywhere. There's people who are going around hotels and just saying, "Oh, I drove," saying I can't get into this space. There is a new app for that though. It's a positive app that's saying, "Hey, it's to help people. Hey, I've been to this venue. Don't go in here, right? Or this is how you get into here." It's actually built by people who have physical disabilities to share, what they experienced in a positive way. I say a positive way. It's to bring awareness to that community, but also to those venues saying, "Hey, we can't access this."
Yeah, and
Right?
it is too bad that some people do take advantage because it hurts the rest of us.
Right. Exactly. Are there any misconceptions around dietary needs and disabilities? And I'm gonna say that I'm gonna ask that question that employees and employers should be aware of. But I'm like, okay, so I got a call from a magazine 2 weeks ago and said, "Hey, we've got a meeting planner who says that she's getting a lot more requests from people with long lists of here's my dietary needs," right? And so very, very personalized. And I've gotten a few of those, in my career, not enough to warrant that. But so is that I kind of lost my question in that, but it's like, how do we not challenge that, but how do we manage that? Because if it's a long list, like I've gotten one that's a page long of here's my dietary needs. I can't provide, I can't eat any of these foods. Please feed me. How do we handle that from both sides?
Well, so then that comes back to whether it's a burden, if it's an undue burden.
Okay.
Or if it's a fundamental alteration of the way so let's say you're providing kosher meals and somebody has a restriction that they want you to vary the kosher meal. You could push back and say no, because that's going to fundamentally alter the way we do things. So again, there are some defenses, but unfortunately more and more people are getting food allergies and getting multiple food allergies. My cousin was diagnosed with about 6 food allergies in her 50s.
Wow.
So unfortunately, we're going to see more and more of this.
Well, and somebody was in some social media feed the other day was arguing like, Leanne Mandelbaum actually posted something about a very unnice person on a plane. They made the announcement before they got on the plane that somebody on the plane had a peanut allergy and please don't bring peanuts in. Well, this person went and bought peanuts and walked up and down the aisle, passing out peanuts themselves. Like, really nice, sweet person there. That's Sue. It goes back to that scary thing. I mean, it's like, it's really scary that somebody would actually do that. And I guess it is your fundamental right to eat peanuts if you do, but don't you have a heart at the same time? Or my thought process on that is like, that's a confined space. If they go into anaphylactic shock and you're up in the air, they're going to have to make an emergency landing, dude. So you're going to be
affect you. Exactly.
Right. Yeah.
Exactly. Well, so that reminds me of my good friend whose son has peanut and nut allergies. She overheard, so they were doing a food-free celebration, and she overheard some mothers talking and saying, well, what if we get the grandmother, to bring in the cake? They're not going to refuse a little old grandmother coming in.
Wow.
So they were like plotting ways that they could get this cake back into the classroom. And she was just horrified.
Yeah.
But so there is one case that I found. So
we were doing really well there. I lost you. There's one case you found.
A mother was suing a school for a peanut ban, saying that it's basically my constitutional right to have my child eat peanuts in school, and it's a property right that I have, and we're guaranteed life, liberty, and property, so you can't do this. And the court basically came back and said no. So first of all, she's not the one who has standing because her son doesn't, or her child doesn't have the food allergy. But second, what the court said is if the school has determined that this is what the child needs to be safe, a peanut-free environment, then that's what is going to have to happen. And you don't have a right to peanut butter. You don't have it's a school anyway. Right. And it's not a property right. And it's something you could eat as soon as you get home, so those few hours you're at school, it's okay. And another thing is that schools make decisions all the time on what you can wear, what you can bring to school, so a lot of people say, well, they can't tell me what my kid can do in school. Well, they already do. There's already a lot of regulation about what kids can do in school. So, right. So that's the one case I found.
Interesting.
Where a court has basically said it's not a constitutional right in school to have peanut butter.
Well, and that's like, okay, you can eat it as soon as you get in the car, right? Hand your kid your peanut butter sandwich as soon as they get into your car when you pick them up.
Oh, I lost you.
Home. Oh, you did. One of the other things that I wanted to say about that airline thing too is that somebody's like, oh, poor baby, he can't get it. But when you talked about your, the person in your family who's gotten diagnosed with 6 food allergies, is that more adults have food allergies than kids do. And the number of adults getting food allergies as they age is just growing extremely. And people with more than one food, not just peanuts, but it's peanuts and, a variety of other things. So we have to fix that. And somehow, it does make it challenging when you're talking about food allergies.
But a little compassion goes a long way.
Right. Exactly. All right. So to end this, is there anything that you would like, I'm going to put up here how to get in touch with you. What would you say to people somebody who has food allergies, what would you say to them when trying to manage this in the workplace? The ADA in the workplace when they've got a food allergy, and then what would you say to employers as well?
Well, so you have to be careful. You may not want to disclose in your interview that you have that, because even though they're not supposed to deny you employment because of it, people are people. So you may not want to disclose that. But once you do start working, you do want to disclose. Oh, you froze again. I don't know if you can hear me.
I can hear you. Yep. I'm good.
Okay. Yeah. But what I always tell people when they're advocating for themselves is instead of going in and being demanding and saying, you have to do this, you're educating people. You're saying, hey, let me explain to you what happens if I have a peanut. Let me explain why this is important. Let me explain, and I think that goes a long way as opposed to coming in and demanding, because some people don't know. They don't realize. Another thing that I find is people don't realize the emotional aspect of it. They think, okay, you have a reaction, you're in the hospital for 4 hours, and then you're fine. Well, you're not, especially children, and so there's a whole emotional component. This whole, am I going to be segregated because of my allergy? So I think people have to understand that. And I think the more we can educate, the better it will be. So for people to just understand, that's, and that we're not doing it to be a pain in the neck. We're doing it because there's a legitimate medical need for this.
Right. On that note, when you said medical needs, did I freeze again?
Okay, yeah. But yeah, so we're not doing it to be a pain in the neck or to ruin anyone's day or to tell anyone else how they have to live. We're doing it to stay safe and to stay included. And right. I tell the story all the time when I went to see Stephen Colbert. I told you the story. No. When he was on the Colbert Report years ago. And I was in the audience, and I was there in New York for food allergy related things. So he had question and answers. So I asked him, what do you think about, all these people getting food allergies, and, what's your opinion? And forgive my French, but he said, I think it's the pussification of the American child.
Wow.
Yeah. That we're just being too, hovering over people, and I was shocked, because here's somebody who has the public eye, who, and he has since made certain jokes about food allergies too. But for them to think that it's the mother's fault for hovering too much, or making them wimps, or
right.
I mean, it was total misunderstanding that this was a medical condition. This is a life-threatening medical condition, and we're not doing it for special privileges, or, to have our child be special or whatever. We're doing it to stay alive,
right.
and have our kids stay alive. And so that just completely shocked me. So there's probably still a lot of people out there who think that, who think it's just overprotectiveness. It's not really necessary. And then you have the people who say, well, then you shouldn't go at any restaurant if you have food allergies. You shouldn't.
Well, and I think we can't all live we'd all be staying at home. I mean, that's what 32 million people would be, or more, if that's just the US, right, would be staying at home. And that means all of our families would be staying at home too. So I think the fair statistic is, with the 33 million, is that it's like 85 million people are impacted by food allergies. It's the families that are related to those people who have them. So that's a lot of people.
What's interesting, so my son was diagnosed in 2001 when he was 1 year old, and he was diagnosed with multiple food allergies. And so not many people had multiple food allergies back then. I mean, he had peanuts, tree nuts, eggs, soy, sesame, and shellfish. And so my pediatrician said, you might want to start thinking about canning your own foods. I said, what? like Little House on the Prairie? Like, I have to start, raising my own,
carrots and everything in the back. Oh my God, your own cows.
But that was his reaction back then. That was in 2001. Wow. And I just couldn't believe that was his advice. So,
wow.
Yeah, hopefully people have learned more over the years. But.
Right, exactly. And I'm sure that some people, I mean, Amy Graves, who was on the show in May, she's got such a severe corn allergy. She had to move, I think she was in Wisconsin, to California because of their stricter laws around organic and things like that. I mean, she gets so sick from something sits in a piece of plastic that was made from corn, right? Wow. So she has to buy direct from the farmer. She puts all of her food in glass jars, etc. She buys specific shampoos because their packaging is not made with corn, etc. So
tell her to go onto my website, because I have a 92-year-old client who was diagnosed with a corn allergy in the 70s.
Really?
Yeah.
Okay.
And so I did an interview with her, and I have on her blog, one of my blog posts, the video of her talking about what it was like and how she advocated for herself. And she worked with Dr. Theron Randolph, who was one of the pioneers. If you Google him, he's one of the pioneers of food allergy research. He was one of the people back in the 60s who was saying that there were chemical sensitivities when other doctors weren't. And she actually was treated by him and knew him. And so she got a drug that didn't have corn listed in the label, and she got really sick and had all kinds of problems, and sued the company herself, handwritten pleadings, 60s and 70s, went all the way up to the Supreme Court. She hand wrote a petition at the Supreme Court. It didn't go anywhere, unfortunately, but she's an amazing woman, and she talks about what it was like growing up with a corn allergy that people just didn't even believe existed.
Interesting. All right, I just found that link, so I'm posting it in the chat here for everybody to see.
She's an amazing woman.
Okay, yeah, I will watch that video. Thanks for sharing. Yeah.
Is that her dog? free eats a lot of natural foods, and maybe that's helped preserve deer.
Well, yeah, it's used in so many things. It's crazy.
So yeah, a little diversion, but she's an amazing
No,
woman.
okay. No, I will definitely send that to Amy, and I posted it for everybody to look at. So, well, thank you so much, Laurel. I really appreciate it. And it understanding food allergies and the legalities around them are really, really important for us to all understand. And hopefully, with food codes and other kinds of things, we can get to safer experiences for everybody and more inclusive. So,
Yeah, that's the goal.
all right. That's the goal. Exactly. And again, I'll put up here, this is how you can reach Laurel, theallergylawyer.com. And I'm excited. As I really appreciate somebody just posted in here. Let's see, comments. Where did my comments go? New comments. Thank you both. Great episode from Nancy. Thanks, Nancy.
Thank you, Nancy.
Here. Next week, it is October, which is crazy that to think it's October, but we're going to talk about oysters. And I have a female fisher, oysters and seafood. And I'm so excited to bring to you a woman from North Carolina that is really pushing forward some information about seafood and sustainability. So Heather just wrote in, thank you both. This is very educational. All right. Until next time, everybody, stay safe and eat well. Thanks.
All right, thank you.
Thanks, Laurel.